Welcome to Talking Law with Darrell O'Neal. I'm your host. I got my main man, Jerome.
What's going on, Darrell?
Man, another day in the neighborhood.
Yes, sir. Yes, sir.
Look, so if you have Facebook Live, YouTube Live, you have the Apple TV, you have the SVP TV Network app, you can just watch us live. And if you got any questions or concerns, you can call us and ask us right live on the air, those questions. And we'll answer those questions regardless of what we're talking about.
In real time.
In real time.
Yes.
Today, and we're going to give our shout outs here in a minute, but I want to give you a heads up. Today, what we're going to do is we're going to talk about defamation, Facebook bullies, and posting photos of other people online without their consent. Jerome, I hear this all the time. Can you sue, or who can sue, and why you can sue somebody?
Darrell, that's a very good question because as you and I know, you can sue anybody, at any time for anything.
Right.
Now, the question becomes, are you going to be able to recover? And if you truly have damages, because you also can get into an area where you have something called malicious prosecution if you are just out there just suing people for absolutely no reason at all. You could run into a problem. And so that's why this show is so important tonight, to make sure that you understand, though it's liberal, there still are some stops to you too. You can't necessarily just do it randomly like that.
And Jerome, you said something, man, that's worth a mint. Yeah. So anybody can sue anybody for any reason. Doesn't matter whether you have a good case, bad case, or indifferent. Now that's anybody. Anybody but lawyers.
Right.
In Tennessee, a lawyer has to have a good faith basis for any lawsuit that they do.
That's excellent, Darrell.
And if they don't have a good faith basis for any lawsuit that they do, they or their client can be responsible for it.
Absolutely. And in fact, just because you come to a lawyer and say sue, the lawyer has an obligation to investigate, just as you said, to find out if there's any inkling of a cause of action involved in your statements.
Yeah.
And there, and this is so important too, because we first have that initial consultation. That's the eye-opening experience where we ask questions and you reciprocate by answering the questions and telling us your story. Now, many times our probing causes an issue because people don't necessarily want to be asked questions from someone they think is just going to acquiesce and go along with anything you say. That's not how lawyers operate. Again, our job is to try to get to the basis of your claim. And sometimes we have to send away and say, you really don't have anything here.
Well, now let's talk about something.
Okay.
And then, Jerome, I want to kind of back into this. So when we're talking about Facebook claims, or we're talking about defamation of character, or we're talking about posting photos without somebody's consent.
And we're talking about slander.
And we're talking about slander.
Yes.
So, and Jerome kind of hit that in the head. So defamation has two aspects. You can have liable, which is written, and you can have slander, which is stated.
Statements.
And if you have liable, it's 6 months statute of limitation.
Okay.
And if you have slander, it's a 1 year statute of limitation.
Okay.
So there's a difference in statute of limitations for the two.
Right.
But before we get into that, the issue when you start talking about what people are saying and how they're saying, and whether you agree with them or not agree with them, hits one Constitution Amendment first and foremost. That's a First Amendment issue. So freedom of speech. So you're saying it's defamation. I get to say what I want to say, when I want to say it, and how I want to say it. The question becomes whether or not there's some malice in what I'm doing and saying.
Right.
There's the question of whether or not I'm lying when I'm saying what I'm saying. And the question is whether or not what I'm saying, if I'm lying, it causes harm to another person.
And there you said something very important there too, because there is one defense to all of these claims, and the truth is an absolute defense.
Yeah.
Now, I can't make up something about you, and I cannot share some information I've heard without there being some inkling of truth in it, because then you're opening yourself up for damages in that way. But if it's true, if you've done it, no matter how long ago it was when you did it, then they have no claim.
Right.
Yeah.
So let's talk about this. The First Amendment protects a person's rights. And let me just tell you, the one that we know about this is real. Every human being knows about this. There's a guy named Larry Flint.
Flint. What's his name?
Flint.
I think Flint. From the Hustlers magazine.
Hustler magazine.
Yeah, right.
And what Flint did,
Right.
it says, I have a right to publish pictures, content, anything I want to.
Right.
Because my First Amendment allows me to do that.
Right.
And he fought for that. Filed lawsuits and all that, and he won that. Because the Supreme Court said, you have the right to do certain things. And if people agree, disagree, don't like it, do like it, it's my freedom of speech.
That's right. That's exactly right.
So I'm going somewhere with this.
Okay, I see it.
So the First Amendment allows me freedoms of doing certain things. And why is that so important in defamation and slander and posting people's on Facebook and all that other stuff? Is there is a statute called the SLAPP statute. You familiar with that, Jerome?
Not really.
So the SLAPP statute is a statute that protects people's First Amendment rights.
Okay.
So if you file a defamation lawsuit or a slander lawsuit or those types of things, you got to get past that SLAPP hurdle.
Okay.
And if you can't get past that SLAPP hurdle, not only will your case get dismissed, you got to pay attorney fees.
Okay. So SLAPP means what there?
So SLAPP means strategic lawsuit against public participants.
Okay.
Or public participation.
Okay, I got you. Okay.
So that's the long word of it. It's kind of like a shield in the Marvel movies. You know, strategic homeland, interventionist, you know.
And that's good. That's good that people can, because it's very easy to remember that.
SLAPP, you know.
Because I thought at first you were talking about the actual physical move of slapping someone.
I think the way they broke it down
Okay.
maybe was a way to get people to understand the intention of what it is.
Yeah.
And so what SLAPP does is it protects free speech. So you have to establish that the speech that somebody had is not protected speech.
Got you.
And here's the problem with that. If you file a lawsuit, normally the burden of proof is on the person who files a lawsuit. But if the defendant files a SLAPP response, then the plaintiff, who's the person who filed the lawsuit, has to prove that they can get over that freedom of speech protection.
Okay.
You know, and that's what happens. It's called an early dismissal of the lawsuit. And you got to do all that and get that done and get your case, your ducks in a row before you get any discovery. So you can't use discovery as a way to keep your case going.
Is that federal, state, or does it matter? Is it the same in the federal?
Every state has their own version of it.
Okay, I got
you. You know, Tennessee actually has a pretty strong version.
Okay, got you.
You know, and I have people all the time, man, I'm gonna file a defamation lawsuit. Not with me, dog.
Right.
You know, because number one, even if SLAPP didn't exist, defamation lawsuits are extremely hard.
Oh, I can just imagine.
And I had a case where I was defending one of my clients for a defamation lawsuit, and I really screwed it up. Now, I finally ended up getting my client dismissed.
Oh, really? That was good, yeah.
But had I done what I was supposed to do, if I would have filed a SLAPP response, then all the money that my client spent in discovery and all that other stuff would have not been spent.
Yeah.
Because SLAPP requires you to prove that this is a viable case to get past certain hurdles.
I like that, Darrell. I like that.
So, if you go to a lawyer, we talk about this all the time. Anybody can file a lawsuit.
That's right.
Anybody but a lawyer. A lawyer has to make sure any lawsuit that they file is viable. And it hits certain hurdles. They have to make sure that that lawsuit can overcome that SLAPP statute. Because if not, I need to tell you, amen, I'm letting you know, and we're going to put this in your contract. Here are the facts that you gave me. They're not that strong. I ain't filing this. Oh, man, I already paid you. I'm going to pay you to file it.
If you insist on it.
As long as you sign this document, say that I understand
right.
that if it gets screwed up, I'm going to be responsible for attorney fees, then I'm all in.
Right. And Darrell, the most important thing too is we never want to chill conversation. We never want to chill it. And what we mean by that is that the law, that's why the First Amendment is so important, because had it not been for that, you could just about sue a person and maybe recover. But because we don't want to chill free speech, we allow people to have their First Amendment. Now, always important, it is a restriction on it because you cannot yell fire in a crowded theater. Now, that's a no-no. That just surpasses all of your so-called First Amendment rights. And you cannot do speech that's going to cause harm to someone or what? Or destroy someone's ability to earn a living.
Right.
And so those things are important while you're doing your suit filing because you just want to have your day in court.
Right.
That's one of the things we have to deal with too a lot, is that I just need to tell my side of the story.
Right. Yeah.
And that can be expensive.
Right.
Telling your side of the story.
Yeah, and so I was, so I had these backwards. So if it's written, the statute of limitation is 1 year.
Okay.
I don't know if I said it right or wrong.
I think you said it, I don't know.
If it's
well,
written.
Well, you straighten it out now anyway. Yeah.
If it's written, which is liable, your statute of limitation is 1 year.
Okay.
If it's slander, which means that it's spoken, the statute of limitation is 6 months.
Okay.
And that's 6 months from the date of the action. And here's what people always,
I like that.
and this is what people always do, Jerome,
I like that,
on these defamation.
I like that. Yeah.
Well, I just found out about it.
Right.
And so they try to make this discovery rule argument where discovery is, if I just found out, that was when the statute started accruing. But you can't manufacture that.
But there, I was just thinking about that too, because one thing we've not said, and it's very important, is publishing.
Yeah.
Whatever we're talking about as defamation or slander or libel has to be published.
Yeah.
What that means is that they had to either write it and it was distributed, that's publishing, or spoke it in a group or to someone else that can be verified that it happened. That's publishing. And so there, I was thinking when you said the statute of limitation would run in 1 year, but it's each time that same thing is published. That renews it again. That's what I was trying to get to. Yeah.
And Jerome hit it, and he kind of dovetailed right to where we need to go.
Yeah.
He says publishing. Well, guess what? If you put it on Facebook, that's publishing.
Publishing.
So now you have published something about somebody to a third party.
That's right.
Again, publishing to a third party. Like, okay, if it's me and you, and I say it to you,
right,
or you say it to me, or I write it to you, or you write it to me, that's not publishing.
That's a he said, she said.
That's a he say, she say. But if I write it and I send it to Facebook, or I write it and send it to your family member,
or you hit
or your job,
do an email, and it's blasted all over the place.
That's publishing.
That's publishing. Right.
And again, the defense to slander and liable is the truth.
Absolutely.
So if you know the truth,
absolutely,
or it is the truth, that's it.
Absolutely.
I mean, that's an absolute defense.
Yes.
But what SLAPP does is it allows you to not even get there.
Which is amazing, which is wonderful.
That's where
that you can short circuit this whole thing by using the slap rule.
Well, it's the expense factor.
Yeah.
I mean, the whole part of this is that, that you're just, the whole point of that is, you're trying to protect everybody. If you got a viable lawsuit, it will overcome that slap defense.
Oh, yeah.
If you don't have a viable lawsuit, it's not. Now, here's one of the questions somebody sent us.
And one more thing, Darrell, before we get there. Also, we got to be careful, too, when we're dealing with minors, too. Wow. There's a whole different thing there. If the individual is a minor, you can wind up in federal prison by doing anything with a minor. So
I tell you what.
Careful. Yeah.
All chips are off.
Yes.
If it's a minor.
Yes.
If it's a minor, don't do it.
Right.
I mean, don't
republish.
If somebody sends you a picture inappropriately of a minor,
right,
don't republish.
Don't republish.
Don't show nobody.
In fact, don't even click on it.
Don't keep a copy of it. I mean, if you have, and it's funny, and I'm digressing a little bit, but they have charged kids in school.
Yes.
It's called sexting.
Yes.
So they'll send a new picture of some girl that some girl sent to them.
To her boyfriend.
Minor boyfriend.
Right, minor boyfriend.
And her minor boyfriend starts showing it to another minor.
Right.
And then some teacher gets it. Now the teacher is in a pickle.
That's right.
Because number one, that's a problem. That's child pornography.
Right.
And it's got to stop. And then he's got to turn it over to administration, and they got to get the police involved immediately.
Yes.
And then those children that were having those pictures that were sending back and forth have basically...
I mean, all of them.
All of them.
All of them in trouble.
All of them in trouble
yes.
because that's child pornography.
Yes.
Because a child can't even give permission
that's right.
to send those pictures.
That's right.
Or permission to receive those pictures.
That's right.
That's pornography, and that's illegal.
Right.
But one of the questions that we got here was, what if a person posts on social media a naked picture of somebody without their permission?
Well, interesting, and this is good, and that's what we do. Like whenever we are trying to determine what the issues are in a consultation is. So first of all, where did the picture originate? Is it between two parties? And so a lot of times we see where people who were in a relationship with one another, and then they break up, and then one of the parties start publishing this kind of material. That's definitely, in my opinion, that's a violation, and that is a claim that you can sue.
It ain't a claim you need to sue on. No. That's criminal.
Oh.
Tennessee actually passed a criminal statute.
Okay.
That specifically say you can't. They call it revenge porn.
Okay.
Is what it really is called.
Okay.
You basically have pictures of your ex, and you've kept them, or some girlfriend or somebody that sent pictures to you.
Right. Right.
And then, but they authorize you to see them.
Right.
But they didn't authorize you to show somebody else.
That's right.
So if you put those pictures anywhere else, even though you're authorized to have them, you're not authorized to send them to somebody.
That's criminal.
That's criminal.
And it's a felony.
I don't remember.
I think it may even rise to the level of being a felony.
Yeah, it's definitely criminal.
Okay.
So let me just tell you, you Facebook junkies, if you got a naked picture of somebody, do not post that picture. I don't even care if you got permission.
You know what? And I think that's very important.
Even if you got permission, don't post that
because how can you prove that you were given permission to publish it? You follow what I'm saying? So you wouldn't even do it if you got permission, but how would you prove that you had gotten permission to send it to someone else, to a group?
So I think there are some certain requirements
Oh, okay.
to publish nude pictures.
Okay.
So even with permission, there are certain requirements. So there is this age issue.
Mm-hmm.
You got to prove that anybody that can or will that see it is above the age of 18. So there's a lot of vetting and stuff that you have to do. I'm not a subscriber of it, but they have all this porn that you can buy online.
Right.
And one of the issues that a lot of the states had, Tennessee did it, Mississippi did it. They had a thing where is that you can't have access to that unless you prove that you're above the age of 18.
Oh yeah, I think that's one of the things that they require before you can click on it. But I mean, kids gonna click on it anyway.
And they're gonna lie.
Right, they're gonna lie.
And they're gonna lie and say, man, I'm 30. Right. 30 years old, dog.
Just like they have false ID to get into the club.
Yeah.
That's the same thing.
Yeah.
So, and you know what? And there too, that's good. Because, in the law, we always have this thing called knew or should have known that a child would still access this information. Well, I didn't know children were gonna look at it. Well, if it's available. And also, it's something called attractive nuisance in the law too. So,
yeah. I mean, look, this is not good.
Not good at all.
And this could go bad a gazillion ways.
Yeah.
Now, I know that Facebook and some of these other places, YouTube and TikTok and all that.
It's mostly going to be TikTok.
And they have those pictures where people do, new things and, different scenarios and different shows and all this other stuff. But I don't know what they've done to vet that and how because again, there are some issues. There are some, the law is totally different when you start involving nudity.
I think so too.
Yeah.
But I was just thinking too. I do go on Facebook many times to see our show as often as I can. But I also see other things like this thing they call women who are gold diggers. And so
you too deep in Facebook, dog.
And so the guys,
women gold diggers. What the hell?
Well, so the guys are approaching women to try and see how much information, how willing they are to even speak to them when they're just dressed normally. And many times the women will reject them because they don't look a certain way or they don't, their appearance is not. But when they go and get into a Lamborghini.
Oh, I saw one of those before.
That's what I'm talking about.
I did see one of those.
I know you kept looking at me.
I'm like, where are you going with this, man? I was like, we ready to get Jerome some porn. Jerome to talk about, porn.
No, I'm talking about like when they get into the Lamborghini, or they get into the Porsche, or they get into some fancy car, all of a sudden it all turns around, and they come running back to the same individual.
I've seen those before. I did see one of those before.
Okay, so
actually I saw a couple of them before.
Okay, so that's what I'm saying.
Yeah.
So now I know they didn't get permission to have those women on there like that, and they have them turning around, shaking their fannies, like that's what my daddy would call it, shaking your fanny. But and they are willing to just about do anything for a guy who they just rejected moments ago.
I think they made, because I don't know if you remember, and this guy finally ended up going to jail. You remember that thing called Girls Gone Wild?
I do remember that.
So
I do remember that. Yeah.
So Girl Gone Wild was this guy that had a thing that basically I can entice people to show their breasts, to do all kinds of just crazy stuff, right? But what he would do is he would get them to sign.
Oh, for sure.
Sign a release authorizing him to show that stuff.
To show it, yeah.
Because if you're showing pictures of other people, I don't know if you watch shows sometime, you see people blurred out. If you see people that are blurred out, that means that they didn't give their permission. If you see the faces of people, that means that they did give their permission.
Okay, I got you.
You can't benefit from somebody else without their permission.
Using their likeness.
Using their likeness without their permission.
Right, without permission.
But I think it changes maybe when we're on a public street, right? You're not a minor, the person's not a minor. So you're on a public street, you're in my car.
Well, I haven't gotten in your car yet.
Or you.
I'm inviting you in my car.
But I'm filming a public street.
Okay.
And you walk through the public street and I'm talking trash.
Okay.
And then you don't want to do anything, and then I'll go get in my car, and then
you come running
and jump into my car. Again, you in my car. So,
but the conversation continues even while they're in the car.
Yeah, but you're in my car.
Right. Okay.
So I don't know. I still think that there's some privacy laws and possibly there. I don't get behind the scenes on that enough. I'm certain that there's some vetting here.
But also there too, I just thought about it. Some places you can't record another person without their permission.
Correct.
So how do we get past that?
Well, okay, those places are non-public. I don't know if you ever noticed that all of those things that we're watching, those shows that you see like that, they're on public streets.
Right. Okay.
And in fact, if you ever notice that, you'll see, people that want to stir up nonsense, they'll go into a court, not a courthouse, but they'll go in a police station and film. Again, you can do that because it's public.
Okay.
On a police doorstep, in the courthouse. Now you can't film in the courtroom because there are statutes and rules around that. And you can get permission and then you can film. But you got to get permission from the court to do that.
And these things just keep popping in my head about where do you have a reasonable expectation of privacy? Do I have a reasonable expectation of privacy when I'm walking down the street?
No.
Absolutely not. Because the streets are available for everyone.
Right. And, they did some of that stuff with cell phones. They do that stuff with, if you're talking on a cell phone in public, can the police use information that you're saying during, now not while you, not what's on the phone, but if I'm looking at you reading your lips and you're in a public place and you're talking, can I use that information? Again, it's a reasonable expectation of privacy. You didn't ask for one because you're doing it in a public place.
Right.
But if I'm in my car, there's a reasonable expectation of privacy.
That's right.
Because it's in a confined space.
That's right.
If I'm in a phone booth where the door is closed, even though it's a public phone booth, the reason why they have a door is reasonable expectation of privacy.
Exactly.
So, you got to look at these things and work through them. But, what we want to let you know here, and we're really going to, I'm glad Ms. Debbie talked about this because we want to go ahead and do another show on this. Because we hadn't gotten into the deep meat of it.
That's right.
But what we got into today is that anybody can sue. The First Amendment of the Constitution protects a lot of speech. So if you're going to sue somebody for something they said or did, make sure you can get past the First Amendment. And then naked pictures anywhere, not good. And children are not good.
Right. Oh, for sure.
So, those are the arenas that we've talked about so far. But, next week, we really want to get a little deeper into the defamation of character aspects of them, the Facebook bullies. And I think we talked a little bit about posting without consent, but I think next time I want to have some case law, some statutes, some things of that nature so you can see exactly what we're talking about.
I think that's good, Darrell.
Yeah.
Yes. But also one more thing. So in certain areas, the scrutiny is stricter. As say, for instance, in a school where there's loco parentis, where the teachers and stuff are like the parents for kids, and their protection is heightened in those areas. So some things you could do on the street you can't really do in a school system.
Yeah.
Where minors are.
Right. Well, so there's other laws. Children, again, they're minors, which means that they can never give a consent.
That's right.
Under no circumstances can a minor give a consent unless they're emancipated. So we don't want to get into that. Right. And the other thing is, the FERPA laws, and we'll talk about a little bit more of that next week. All right, y'all. Well, we got a lot to do for next week. And look, you better, man, you're going to have some questions next week, man. You got some Facebook questions next week, man. That's going to be your week.
Oh,
we're
yeah.
going to talk all we can about Facebook. Thank you for watching the show. We'll see you back next week.